the last thing I think we might think about, and this in some ways is the most important thing, it seems to me, to think about, is what happens now. For people on both sides of the issue, where are we left? The court having exercised the judicial review power, we're sort of out of the judicial system, at least for a while, and we have people on both sides of the issues with understandable positions, and I guess what's important now is to understand the newly established framework for debate. What's on the table and what has the Supreme Court taken off the table? Well, one thing that's on the table is the type of weapon. Justice Scalia's majority opinion in the Heller case provides fairly clearly that the court understands the Miller case to have interpreted the Second Amendment in ways supported by the Heller majority that deny Second Amendment protection to arms, to weapons that are, and this is the Heller court's phrase, not typically possessed by law-abiding citizens for lawful purposes. Well, there are arguably lots of weapons available that are not typically possessed by law-abiding citizens for lawful purposes. So it seems to me that there needs to be some fruitful discussion, some meaningful, reasoned discussion as to what the limits of that language are. It's clear from Heller and McDonald that handguns are on the protected side, but we don't really know about much else because we don't have any Supreme Court case law since Heller and McDonald on other types of weapons. We also don't have any Supreme Court case law on ammunition, and this is something that folks talk about a lot too. And it seems to me that there's room for discussion there. There's room for compliance with the Supreme Court decision that would eliminate some of the things that folks who are in favor of greater gun restrictions are concerned about. The second general avenue that's still open has to do with, well, what if a particular weapon falls on the protected side? What if it is characterized as something that is commonly or typically possessed by law-abiding citizens for lawful purposes? Does that mean that there's no possibility that Congress could regulate its possession? And of course, we know the answer to that is true. We talk about background checks and this sort of thing, but I think it's important to understand the methodology. What the court has suggested is that the Second Amendment right would be treated like other rights recognized in the Bill of Rights, which is to say it wouldn't be absolute. It's not an absolute right. But it's very hard for the court to actually do anything that might jeopardize the exercise of the right. The typical test for government infringement of rights that are held to be fundamental is what we call strict scrutiny review, which is to say that before the government, federal government or post-McDonald, the state governments, can constitutionally interfere with the exercise of the right, they have to prove that they have a compelling reason for doing so, and that's a hard test to meet. And then they have to prove that the method that they've chosen to meet this compelling end is necessary, that essentially they've considered other non-restrictive or less restrictive alternatives and they won't do the job. If the government fails on either of those, either the means portion or the ends portion of strict scrutiny analysis, then the government loses. Now, it's a hard test to satisfy. It's very infrequently satisfied, but sometimes it is. Now, all of this is to say that the conversation isn't and shouldn't be over. A lot of really, really terrible things have happened recently that have triggered a renewed and very passionate interest in the scope of the Second Amendment, the problem of violent acts involving children, and as we know, the problem of violence in urban areas in general, which probably draws less attention than it should. So what do we do about this? Well, nobody's in favor of acts of violence. So there's some common ground. Everyone's supportive of the Constitution. So there's some common ground. The country accepts the judicial review power for the most part, so there's some common ground, and we've got recent Supreme Court case law that provides guidance. There's opportunity for conversation on types of weapons and on the severity of the problem and the value of various proposed solutions that relate to restrictions on gun ownership rights as solutions to the problem. And I think there's meaningful positions being advanced by both sides on this debate. If there comes to be a broad consensus, or even anything approaching a broad consensus, on the importance of the solution, of finding a solution, and I think that probably already exists, and a consensus, or at least some sizable support for a particular solution to that problem that relates to restrictions on Second Amendment rights as recognized by the courts, then the government can attempt to run it through the judicial process, and we'll see. It's a conversation that's important. It seems to me it's important that the conversation be conducted with an awareness of constitutional limitations as established by the Supreme Court, with which we all currently have to deal. It's important, it seems to me, that everyone keep their eye on the ultimate goal, which is solving a problem which we all agree is unsustainable, and that people relate to one another within these limitations in a thoughtful, reasoned, and mutually respectful manner.